Good afternoon and welcome. I hope this finds everybody healthy and doing as well as possible under these circumstances. Delighted to welcome you to the next in this series of presentations about legal issues with regard to the coronavirus. This is going to be presented by two of our professors, Katie Albiston and Catherine Fisk. As always, I will just do the shortest of introductions. KT received her bachelor's and master's from Stanford, received a law degree and a PhD from Berkeley, began a teaching career, and then came to Berkeley in 2003 as a member of our faculty. Catherine Fisk received a bachelor's degree from Princeton, a law degree from Berkeley, an LLM from the University of Wisconsin, taught at a number of law schools, and then came here to Berkeley Law in 2017.
Sorry.
All of the adventures of doing Zoom.
Yes.
And with that, let's think of that as sort of the equivalent of a drum roll for you. That drum roll, I'll turn it over to KT and Catherine.
Thank you so much, Erwin. So we are a bit of a tag team in this presentation. I'm the opening act and Catherine is the main event, but we will start by talking a little bit about the nature of social insurance in the United States. So in the United States, social insurance is very closely tied to employment. So some forms of social insurance, like health insurance, pensions, paid family leave, and sick leave, are supplied by employers and typically paid for by both employees and employers. Other forms of social insurance are administered by the state but paid for by taxes on employers and employees, and these include unemployment insurance, disability insurance, Social Security, and workers' compensation. Even for these forms of social insurance, which are closely tied to employment, when employment drops, so does access and funding for these forms of insurance. But even in good times, access to these forms of social insurance is shrinking. So this chart shows you that access to employer health insurance has declined. In the 1970s, approximately 80% of the US population had private health insurance through their employers. But now only the most affluent workers are reaching that level of insurance, and employer insurance has declined dramatically for those who are lower on the income scale. In addition, access to defined benefit plans in terms of pensions is also shrinking dramatically, as this chart shows. So plans such as defined contribution plans or 401ks that shift the risk of economic downturns and poor investments onto employees are starting to displace them, and even those kinds of plans are not available for workers who work for smaller employers. Now, this is not good news, but even these declining forms of insurance are only the tip of the iceberg when it comes to the economic precarity of workers. As sociologists Arnie Kallenberg, Neil Fligstein, and others have documented, there's been a steep rise in what sociologists and others call precarious work. So major types of precarious work include things like temporary work, contract work, people who have been shifted into independent contractor status, and involuntary part-time work. Half of the jobs that were created between 1995 and 2013, and about 60% of those created between 2007 and 2013, were these kinds of non-standard jobs. And now more than 17% of workers in the United States are in these kinds of precarious jobs. These kinds of precarious jobs are not equally distributed. Younger, female, and Hispanic and Black workers are more likely to be in these precarious jobs. But the big news is that precarity is growing quite rapidly among white men. Americans are not well prepared to deal with this. A 2018 Federal Reserve survey found that 40% of American adults wouldn't be able to cover a $400 emergency with cash savings or credit card charge that they could quickly pay off. So the most major category of precarious work is independent contractor status, and that includes those that work in the so-called gig economy. So more than 10% of workers rely on gig work for their primary income, according to the Bureau of Labor Statistics, and 20 to 30% of workers engage in gig work for primary or supplemental income. So the nature of labor and the benefits that go along with having a job has changed, such that most non-standard jobs and even some standard jobs lack the benefits like health insurance, pensions, paid sick leave and paid family leave. But our social policies have not kept up at all. So Jacob Hacker, who is a Yale political scientist, calls this policy drift, or an increasing mismatch between the social conditions for which policies were designed and the social conditions that currently exist. And so in the United States, workers face the rise of new or newly intensified social risk without the help of social policies that are much more common in other countries, such as universal health insurance, support for childcare, and paid and family leave. So for example, virtually every other industrialized nation in the world mandates some sort of paid sick leave for employees. Not so in the United States, which has no federal sick leave requirements, or at least did not until a few weeks ago. Also, the United States until a few weeks ago had no federally mandated paid family leave. So what do people rely on if they need leave? They rely on whatever leave their private employer provides, but access to paid sick leave and family leave through private employers follows some pretty predictable patterns of inequality. So access to paid sick leave is greater for full-time than part-time workers, for high earners compared to low earners, for public sector workers relative to private sector workers, and for those who work for large employers relative to small employers. A similar pattern applies to paid family leave, except for only 16% of American private industry employees have access to paid family leave at all. Now, some states have adopted paid leave programs, but these are recent and partial. For example, none of the 200,000 UC employees are covered by California's state SDI program. Okay, so now what we want to do is shift to talk about some of the recent federal legislation that has attempted to fill some of the gaps in our social safety net that have become so glaring in current times. So first, let's discuss paid sick leave. So there are three laws. The Family First Coronavirus Response Act provided the first federally mandated paid sick leave and family leave. So first, let me talk about paid sick leave. So the paid sick leave provision in this statute does not require you to be employed for any particular duration to qualify for it, and it provides 6 qualifying reasons. The first 3 reasons focus on the effects of local quarantine orders, individualized self-quarantine advice, or if someone is sick and seeking a medical diagnosis. And the last 3 have to do, or the last 2 and then the catch-all category have to do with whether someone is caring for someone who is ill or is caring for a child who's out of school. There is a provision for pay such that individuals who receive paid sick leave will get full pay up to $511 per day if they take leave for the first 3 reasons. If they take leave for the second 3 reasons, or the caring for others reason, however, they only get 2/3 pay. So who's covered? Employers that have fewer than 500 employees. So those that are larger are not mandated to provide paid sick leave. Also, employers have some discretion to exclude some employees. For example, employers who are healthcare providers can exclude those who employ healthcare providers can exclude those healthcare providers from the paid sick leave provision at their discretion. And in addition, employers with fewer than 50 employees who say that providing leave would undermine the viability of their business and can document some facts suggesting that in their own files can also exempt themselves from these paid sick leave provisions. Now, even larger employers don't always provide sick leave to all their employees. You may have seen this article in the recent New York Times Sunday edition, which is based on data from a study done by Berkeley sociologist Danny Schneider, and it shows that many familiar large employers with more than 500 employees, indeed more than thousands of employees, especially in retail, food, and grocery, do not provide paid sick leave to their rank and file workers. And so the size of the dots here tell you about how many workers each of these employers employs. So the legislation leaves a lot of people without access to paid sick leave. Okay, the second thing that the Family-Friendly Coronavirus Act, Response Act provides is the first mandated paid family leave at the federal level in the United States. So basically what this act does is create eligibility for individuals who are caring for a child who is out of school or out of childcare because of COVID-19. And it reduces the eligibility requirements to somebody who's only been employed for 30 days with some provisions for people who are laid off and then rehired. Now, one has to ask, why is it that caring for a child who's out of school is covered by this, but not caring for a sick child, a sick parent, or a sick spouse? That was not clear from the legislation. This provision works with the paid leave provisions so that the first 10 days are paid through emergency sick leave, and then the next 10 weeks are paid through the paid family leave provision. And again, the pay is at 2/3 the regular rate of pay, up to $200 a day and $10,000 total. One has to also ask why it is that time off for caring for someone who's ill is paid at a lower rate than time off for someone who is sick themselves, because the lost wages are the same. A feminist might argue that this is another example of the devaluation of caregiving, which is disproportionately performed by women. Okay, now I'm going to turn it over to Catherine to talk about the CARES Act.
Thank you, KT. The CARES Act was the second major piece of legislation that Congress enacted to respond to the coronavirus pandemic. It's the one that everybody called the $2 trillion stimulus. It addresses the phenomenon of an unprecedented number of jobs lost in a short period of time. As you can see from this chart, with data reported in the New York Times but sourced from the Labor Department, more than 26 million unemployment claims had been filed since the pandemic started in 2020. And I should say that that 26 million claims, some estimate 33 million people unemployed, rivals the depth of the Great Depression in the middle 1930s for the largest number of people unemployed in American history. The CARES Act addresses this catastrophic level of unemployment in two major ways. First, and I'll talk about those first, it has benefits that are paid directly to workers of several kinds, both the $1,200 checks that were mailed out, many of which were mailed out earlier this month, as well as unemployment. It also has some catch-all provisions allowing employees essentially to borrow against their retirement accounts. The second form of benefits that I'll then discuss are you could think of them as benefits paid indirectly to workers via loans for employers that are intended to incentivize employers keeping people on the payroll. And then the CARES Act had some other benefits. So taking the cash rebates first, the rebates, some of which have already been paid, some of which are being paid, were $1,200 per individual, up to $2,400 for couples filing jointly. They're phased out starting at $75,000 of annual income and no eligibility for those earning above $99,000. In addition to the $1,200 payments, families can apply for an additional $500 for each child in the home under the age of 16. This money is paid tax-free, and any person who filed a 2018 or 2019 tax return should have or will receive the payment, leaving aside some really alarming incidents of fraud. The money, however, is paid only to those who filed tax returns and only for those households in which everybody in the household has a social security number. That winds up excluding immigrant families, including immigrants who are lawfully present and working in the United States. The second form of direct payment to laid off workers are expanded unemployment benefits. The unemployment insurance program is a joint federal and state program. It's funded partly by the states and administered entirely by the states, and funded partly by the federal government. The CARES Act extended unemployment benefits for 13 weeks beyond the usual 26 weeks for which workers are eligible. And in addition, it added $600 per week on top of whatever benefits a worker would have been eligible for up to 4 months through the end of 2020. That matters a lot because benefits for unemployment vary from state to state. In some states, they're more generous, and some states, they're less generous. But the average weekly unemployment benefit is only $385. The CARES Act significantly expanded eligibility for unemployment benefits. For the first time in American history, self-employed workers, independent contractors, gig workers, freelancers become eligible for unemployment benefits. They will collect benefits on an amount based on a federal formula, since they don't have an earnings history. That is the usual way that states determine benefit eligibility. And the reason they don't have an earnings history is because they haven't previously been eligible for unemployment insurance. It's important to note that either workers can be eligible for the sick leave or family leave that Professor Albiston described, or they can be eligible for unemployment benefits, but they can't be eligible for both. And the giant holes in eligibility that she described, essentially in family leave and sick leave, are essentially being covered by unemployment benefits. Still, some are ineligible for unemployment benefits. Obviously, those who are still working, even if they're working fewer hours and earning significantly less money. Those who are receiving paid sick leave or family leave. Those new entrants to the workforce who have no work history and cannot find a job. So high school graduates who are graduating this month or next month, who were hoping to find jobs, college graduates who cannot find jobs. None of them will be eligible for any form of unemployment insurance. And importantly, undocumented workers in the vast majority of states are ineligible for unemployment benefits. No matter how many years or how many hours they worked, they are ineligible. In California, because California protects undocumented workers more than many states, DACA recipients are eligible for unemployment benefits. But that still leaves a large number of people who are not protected. Although the CARES Act expanded eligibility and funneled a great deal of money into the state unemployment insurance funds, there have been tremendous problems in the administration of the system. Nearly 1 month after the CARES Act became law, it became law a month ago today, most newly eligible workers have still not received the pandemic unemployment assistance benefits that are available to independent contractors. Only 10 states have started paying PUA benefits. California is taking applications for PUA benefits starting tomorrow. State unemployment agencies are overwhelmed with huge backlogs of unprocessed claims, erroneous denials, dubious denials. The system is tied up in appeals of denials. And what this means is that over half of poor households and 40% of middle income households who reported COVID-19 related job loss may not be getting their benefits, and these families are the ones who are least likely to have savings to tide them over a period of unemployment. Whereas higher income households are both less likely to have reported pandemic-related job loss, more able to survive on savings, and potentially more able to navigate the system. The second form of benefits that the CARES Act provides are indirect benefits. The best known of these programs is the so-called Paycheck Protection Program, which is for small employers, those with less than 500 employees, including full-time and part-time workers. The system operates as loans administered by the Small Business Administration. Like most SBA loans, the federal money is funneled through private banks, which then take loan applications and process them and hand out the money. These loans are forgivable, that is, they become grants for certain employers under certain circumstances as laid out on the screen. They are broadly available for both for-profit and nonprofit organizations, 501c3s, for example, 501c19s. Significantly, they're not available for labor organizations, even though labor organizations have staff who are out there working hard to help unemployed and endangered workers. And even though many labor organizations, such as Actors Equity, have high levels of unemployment among their membership and therefore have no revenue coming in. You might know that Actors Equity, the union that represents stage actors, has zero employment of its membership now because all theaters are closed. The PPP benefits are also available to self-employed individuals as essentially paycheck loans. The administration of the PPP program has really struggled. As you may know from this article from last week's New York Times, small businesses who were seeking PPP loans, in many cases, were put at the back of the line when they went to banks to get these loans, because banks, as they often do, have better relationships, as they would put it, with their major clients. And so larger clients with larger accounts didn't have to use the glitchy online portals that small businesses or self-employed people had to do. This matters because the Paycheck Protection Program ran out of money by the second week in April. And so those entities whose loans were approved faster got the money, others did not. The Paycheck Protection Program third coronavirus legislation that became law last Friday puts another $300 million into the PPP program. And so it's hoped that the small employers who didn't get approved the last time around will finally get some money. Nevertheless, there have been highly publicized incidents of large companies receiving loans because of the way the legislation was drafted that allows them to treat each individual outpost as a separate employer. And so Shake Shack was one much in the news. And so there really are questions about how the extent to which this program achieved the goals that Congress intended for it. There is a fallback provision in the CARES Act for businesses that didn't get PPP loans, either because the money runs out or because there was a problem with their application or a bank considered them too poor a credit risk. This is a tax credit system which allows, as you can see, 100% tax credits equal to half of each employee's wages with a cap. But of course, the utility of a tax credit depends on the business owner's judgment about whether they are going to have a tax liability in the future that would make the tax credit a reasonable incentive to keep somebody employed. There is another loan system created by the CARES Act for businesses that are too large to qualify for the PPP program. This is loans directly from the Treasury Department. As you can see from the criteria listed on the screen, there are a variety of protections in this loan program to make sure that the money is used for the purpose of protecting jobs rather than to prop up profits for shareholders or for senior managers. And so, for example, companies are banned from offshoring jobs for at least 2 years after the loan is repaid. The loan must be used to retain the workforce through the end of September. And this is one of the very few provisions in federal law that has protected workers' rights to organize, that has been enacted in 70 years. This law requires employers to abide by collective bargaining agreements with their union if they have one, and to remain neutral in union organizing efforts during the term of the loan. The CARES Act also provided a great deal of money, although nowhere near enough, for public sector to help offset the huge costs that state and local governments and public entities are encountering. So there's $150 billion for local governments for COVID-19 expenses, $45 billion for state governments for other programs, $25 billion for transit agencies for operating expenses. That sounds like a lot of money, except for it was reported in the San Francisco Chronicle this morning that BART is losing $37 million a week, and that's just BART. So this is nowhere near enough to account for the full losses. In the education sector, public K through 12 institutions and higher education institutions are receiving money under the, and this is not just public, this is actually all education institutions are eligible to receive money under CARES Act. But again, although $14 billion sounds like a lot of money, it's nowhere near enough. You may have heard that the University of California is projecting a $2 billion loss just for this year. And that's just the University of California. So there is a lot of money, but people worry that it will not be enough. In addition, the CARES Act provided additional money for food assistance programs, $15.5 billion for the SNAP program, which is food stamps, $8.8 billion for child nutrition, $450 million for food banks. But it's important to note that the additional money for food stamps does not expand eligibility. It's just there in anticipation of increased demand for those who are already eligible. And there are quite strict restrictions on who is eligible for food stamps. And then finally, the CARES Act added a lot of money for the airline industry and the health industry. It's worth pointing out that the $46 billion for the airlines is the only money in the CARES Act that by law is channeled directly from the federal government to employees through their employers. The other money goes to the company with a variety of set of incentives to maintain employment, but airlines are actually required by the law to channel the money to their employees. There are a lot of gaps in the CARES Act, and some states are filling them, some are not. I'm going to focus here on California. As California identified various very significant holes in the CARES Act, Governor Newsom announced a variety of programs to protect those workers who are excluded. For example, as Professor Albiston described, there are various workers who are carved out of eligibility under the family-friendly corona, or the FFCRA, the Family Friendly Coronavirus Response Act. And so California is expanding sick leave for food service workers. And the reason for this is to encourage those workers who are essential, and food service workers are essential, to be able to stay home if they are sick. A second giant hole in the CARES Act is the hole for undocumented workers, including farm workers who are both food service workers and essential, but also, as we all know about farm workers, highly likely to be undocumented. And so California created a $125 million program for undocumented people. This program is funded with $75 million contributed by states and $50 million contributed by foundations and nonprofit organizations. It's to be administered by nonprofit organizations, not the state, in order for people to be able to claim benefits without fear of deportation. But the amount of money is tiny compared to the need, $500 for individuals, $1,000 for families. And it's worth noting that the program has not even started yet, even though huge numbers of people have lost their jobs. A third California program that the governor created, $100 million to support childcare services for essential workers. It's essentially intended to subsidize childcare available to healthcare workers, emergency response personnel, law enforcement, food service workers, and to ensure that they are safe. The details of how this program are going to work are still being worked out. So what Professor Albiston and I have described is an incredibly complicated multi-part system. This flowchart, for which we get no credit for designing it, I couldn't have done it if my life depended on it, designed by the labor law firm Weinberg at Rosenfeld, illustrates the tremendous complexity of the different programs that are available and the different ways in which people can apply. And the point that we want you to see here is that the complexity of this patchwork of programs creates problems because these are, in many cases, unemployed, stressed workers who may or may not have full English language fluency and who are a bit overwhelmed by the circumstances, have to navigate a really complicated system with many possibilities for them to be told, oops, sorry, you're not eligible, go apply for some other agency. So now we're going to look at what we think all this might portend for the future. This slide suggests that there are two possibilities, and depending on whether you're an optimist or a pessimist or some combination of both, you might see one or the other as being more likely to occur. The optimistic vision is that the COVID-19 legislation might be the beginning of a transformation of the American welfare state. As Professor Albiston pointed out, the United States is unique among wealthy, industrial, post-industrial, highly developed economies in having relatively little public social safety net. Most social insurance, health insurance, retirement insurance, sick leave, family leave, disability leave is funded entirely or in part by employers, either directly or through payroll tax systems, and eligibility is typically limited only to those who are categorized as employees, not as independent contractors. And lower wage workers are less likely to be eligible for any of this form of social insurance. What the FFCRA and the CARES Act do is expand eligibility to independent contractors, to people who previously were not eligible. And it did so because we recognize that it is bad for the public health and bad for the economy for such a significant part of the workforce to be entirely unprotected from risk. But the less optimistic possibility is that the depression that may result, that probably will result from the pandemic, is going to exacerbate pre-existing inequality. We've already seen that in who can work from home and who lost jobs, whose health insurance continues, whose doesn't. We've seen racialized patterns in deaths from the coronavirus. And so depending on whether going forward, we continue to have legislation that funds adequate social insurance for everyone, we may see much greater inequality, or we may see an amelioration of the extreme inequality that we saw before this crisis. But it's important to note that the workers who are most essential in our current essential worker framework, that is, those people who are still by law able to go to work and who are required by their employers to go to work, have the least protections. So nursing, psychiatric assistants, home health aides have no paid sick leave until the FFCRA. Farm workers earning the minimum wage, or in many cases less, do not tend to have health insurance. The other big picture thing for us to think about is where the money is going to come from to pay the benefits that are already being paid. Unemployment insurance historically has been funded by payroll taxes paid by employers. The reason why companies designate their employees or their workers as independent contractors, even if some people believe, as in the case of Uber and Lyft, TaskRabbit, et cetera, they should be designated as employees, is because by designating their workers as independent contractors, they can avoid paying all of the payroll taxes that fund disability leave, paid sick leave, unemployment insurance. And so it was astonishing, for example, when Uber and Lyft, which strenuously resisted paying payroll taxes, then encouraged their drivers to apply for pandemic unemployment assistance, which is the very benefit that they insisted all along they shouldn't have to pay to support. The benefits that the federal government are providing are being paid for by general tax revenue, or presumably will be. At the moment, they're being paid for by deficit spending, which raises, of course, the question about how we should think about taxes to fund this social insurance regime. This chart simply illustrates that Amazon, the largest employer in the United States now, paid a minute federal tax rate, even when its profits were skyrocketing. And that story could be told for lots and lots of companies. And so finally, we want to wrap up with thinking about some of the broader implications of what all of this means. We've seen unequal protections in current policy that amplify existing inequalities, the disparities in who has been eligible for paid sick leave, family leave, unemployment insurance, et cetera. We have seen that the complexity of the legislation and the programs that it creates or funds make it harder for those who are most vulnerable to collect the benefits. And we also see that those who are more sophisticated, who have access to counsel, who have access to pre-existing banking relationships, are more likely to have gotten the PPP benefits. And of course, this is a familiar story generally. Those who are sophisticated, who are repeat players, tend to do better in any complex legal regime than those who are not. And finally, we have seen that the workforce that is designated as essential are also disproportionately likely to be low paid and have few benefits to protect them from illness, unemployment, and family needs. And so it is ironic that those of us who are well protected are not essential. We don't have to go to work. And those people who most need protection are those who are still out there risking their lives to provide services for the rest of us. So we've left some time for questions, plenty of time for questions, and we welcome your thoughts. And I also wanted, since I got to do the big picture wrap up, I wanted to invite Professor Albiston to chime in with anything that I might have overlooked. Thank you.
Yep. I think you did a great job. So let's leave time for questions.
Okay, so if you have questions, you can raise your hand and I'll call on you, or you can send them to the chat and I'm happy to read them out loud. I don't have any at the moment.
Somebody's looking at that crazy chart trying to figure out how to ask a question about all of these different programs. It is a lot to take in.
Oh, here we go. Okay. Reed, do you have a question? There you go. You should be unmuted now.
Sorry. How are states dealing with spending new money if they can't deficit spend? Like, where does that money come from for states like California that are trying to make up for a lack of federal protections for undocumented citizens? I mean, undocumented residents, for example.
That's a great question. There's been a lot of coverage about that recently because of the message from the federal government that there may not be much of a bailout. In California, the prior governor had set aside some emergency funds, and some of that money is being used to fund some of these programs, but it's clearly not going to be enough. And because states can't deficit fund, they're probably looking at raising taxes if they don't get some relief funding from the federal government in some form. Catherine, do you want to say more about that?
Yeah, so states are very different in whether they have rainy day funds. California now has a very good one. Illinois has not. State and local finance is incredibly complicated, and I don't grasp all the details. I do know that with respect to unemployment insurance in particular, the federal government can loan states money to cover unanticipatedly large unemployment insurance claims. That's always been true, and it was announced today that California is going to borrow money from the federal government to cover its unemployment insurance liabilities.
Kaylin Mahar, I've unmuted you. You have a question.
Yeah, thank you, Professor Fisk and Professor Albiston. This is a little bit off of your presentation, but I was wondering, have there been any kinds of protections for workers who are being made to work and put in situations that they don't really have to be? So like, I think like Trader Joe's was encouraging their workers not to wear masks, and workers where they could social distance, but they're not making it mandatory within their workplaces?
That's a great question. It raises an issue about occupational safety and health. The Occupational Safety and Health Administration in those states that are governed by the federal OSHA regime, and in California and many other states, we have state OSHA agencies, are supposed to be protecting workers against unsafe working conditions of various kinds. The Federal Department of Labor, which is the organization that administers OSHA, has taken positions about OSHA and worker safety that are extremely controversial with worker advocates by essentially counting on voluntary compliance and no serious threat of enforcement. Workers are in unionized workplaces, in some cases, are trying to seek assistance from their unions, although that works better with respect to some workplaces than with respect to others. We've seen examples of the consequences of failure to enforce safety regulations. We now have a lot of meat packing plants that have shut down because they became coronavirus hotspots. And they became coronavirus hotspots because the companies didn't take the safety issues seriously. And so it might be that now there is more publicity on this. There may be some actions. Unfortunately, one of the problematic things that's going to happen to workers is if they contracted coronavirus because they were forced to work without safety protections, and many workers have. The United Food and Commercial Workers has already had 25 of its members die from coronavirus, and that's only for unionized grocery stores and slaughterhouses, and the count is probably out of date anyway. Those workers, if they were customers, in theory, could bring tort claims, although business are lobbying hard for immunity from any tort liability. But workers are covered by the workers' compensation system. And so maybe they have a tort claim because the conduct was so willful and so outrageous that it would not be subject to the workers' comp system. But in most cases, workers who are injured or killed because of workplace illness or accident can recover workers' compensation benefits, which is pennies on the dollar compared to what they would get in a tort suit.
And on the other side, the irony of this is that the Department of Labor and the EEOC have indicated that workers who have coronavirus pose a direct threat in the workplace and therefore are not entitled to accommodations, or arguably are not entitled to accommodations unless those accommodations can keep other people safe. So if a grocery worker does contract COVID-19, there's the potential that they could lose their job because the employer says that they can't continue to employ them and keep everyone else safe. So it creates a real conundrum for workers who either are exposed to coronavirus or lose their job after they become ill with coronavirus as the result of inadequate safety conditions.
I've had a few requests from people wondering if you'd be willing to share the slides from this presentation. And I've also had a couple people ask if we can stop the screen share so they can see your faces better. So I'm going to do that.
Okay.
Okay. And then looks like we've got a question from Professor Linos. Professor Linos, you should be unmuted now.
Thank you so much for this incredibly helpful presentation. I hope it is widely disseminated to California law firms and to people in the rest of the country trying to figure out how the new CARES Act works. My question is about the optimistic vision you articulated at the end. There were different elements of what has radically changed about the way U.S. Social policy works following the CARES Act. And I was wondering if you could just repeat some of those points and talk about that vision, because we don't get a lot of good news these days. So leave for everyone, a widely expanded category of workers was one bit I got. Unemployment insurance that has more generous benefits, and large categories of workers who were not previously eligible was another point I got. But again, kind of refining those points and explaining to me how big the impact would be super helpful. The clause requiring employers to stay out of disputes seemed important. And then what puzzled me was the requirement that the fact that certain restrictions applied to small firms rather than to large ones, on the expectations that large firms were already providing these benefits, whether there's also a cutoff that firms employing fewer than 50 people don't have to provide these benefits, or how that works for small businesses would be very interesting to me, and whether that's a big or a small shift. So the optimistic vision, I'd love re-articulated.
Catherine, do you want me to do the paid leave quickly? Because there's little of that. Okay, so the optimistic part of the family leave expansion and the sick leave expansion is sort of twofold. The sick leave expansion is significant because so many workers have zero sick leave whatsoever. So providing at least some is very helpful. The family leave expansion, I think, is important mostly because it's symbolic. It indicates that we are willing to pay people at least some nominal amount for some very short period of time under circumstances that we acknowledge are extremely challenging. And, for 16 years, there have been attempts to expand the Family Medical Leave Act in a variety of different directions. And so it's important in that way. There are some devils in the details that I would hope with that sort of symbolic start might be dealt with regard to sick leave. Half the workforce works for employers with 500 or more employees. And even when those employers provide sick leave, they don't always provide it to the rank and file, as that chart showed. So that leaves a lot of people uncovered. The self-exemption provisions in the DOL regs for the paid sick leave and paid family leave, I think are really hard to justify, where you can just sort of say, oh, well, this would present a problem for the viability of my business. I put a note in my file and I'm exempted. And also the DOL regulations, I didn't mention this, say that even though one of the provisions for leave is that the employee is subject to a federal, state, or local quarantine order, which virtually the entire country is, they go on to say that if the reason that you can't work is because your employer is shut down, this provision doesn't apply to you. And so it's hard to imagine to whom it does apply. So if it says, if the employer doesn't have work for the employee as the result of a shutdown order, then they're not eligible for the paid leave entitlement. So the legislation gives with one hand, the regulations take away with the other. But I think that the expanded coverage and the recognition of this is symbolically important and opens a wedge for perhaps making these provisions, which sunset now at the end of the year, but could be extended, more permanent and more inclusive. And so now I'll turn it over to Catherine to talk about the really complicated stuff.
Oh, the paid leave is plenty complicated. The point you raise is a great one, Katerina. I think the optimistic narrative is, for so long, the discussion about what innovation was in terms of thinking about a workforce was the sort of Uber Lyft story of everybody wants flexibility, everybody wants to work the hours they want and not when they don't, everybody wants to work their side hustle, and therefore there should be no social insurance. The therefore never followed. You could work flexible hours and 2 jobs part-time. I mean, many of us did in those bad jobs in our teen or college or early adult years, where you still were eligible for unemployment insurance if you were laid off. You were an employee, taxes were withheld, and you were protected. And so the thing that I hope the public at large has learned from this is that what has happened with allowing companies to essentially opt out of any health, any retirement, any sick leave, any family leave insurance has been a massive shift of risk that is bad for public health, bad for families, and bad for the economy. And so I'm sort of hopeful, just as the Depression of the 1930s dramatically changed the politics around social insurance and protecting workers, that the Depression that we are now going to be in not to mention the public health crisis, is also going to change the discussion. Obviously, that depends on a change in who is the majority party in the Senate and who is in the White House, but that's a different story.
Thank you.
Professor Albiston, there's a question for you. Can you talk about PFL relief under CARES and how evenly or unevenly distributed it is across workers?
Yeah, so it's sort of the same good news, bad news story that Katerina was asking about. So the good news is that the new provision for sick leave and paid family leave reaches deeper into the workforce, in the sense that everyone under 500 employees is nominally covered. The added reason for qualifying for family leave because of the coronavirus, because children are home because of the coronavirus quarantine orders, you only have to be working for 30 days, so that will include more. So it used to be you had to have 50 or more employees to be covered by the FMLA, and so this new provision now reaches down into smaller employers unless they self-exempt in the way that that I describe. The inequalities are, there's a couple. One is the idea that we're going to provide pay for people who are taking care of kids who are out of school, but not for people who are taking care of people sick with COVID-19. And I just cannot understand why that would be the case. It seems like the need for leave is similar, and I don't understand that distinction. The second inequality is the fact that if you're sick yourself, you get full pay up to $511 a day. But if you're caring for someone else, you only get 2/3 pay, even though of course your lost wages are the same. And so again, I don't quite understand why that distinction, especially given that most care is provided by women. And so the larger lost wages falls disproportionately on women. So there's certainly inequalities there. And then of course, there are many large employers who employ workers who make very little money, as I showed on my earlier slide, who aren't obligated under this new law to provide any paid leave, sick leave, or family leave at all. But some have been shamed into saying that they're going to voluntarily offer it. Walmart is one. And so there may be this is maybe a good news response to Katerina's statement. There may be some isomorphism in that companies start to provide this benefit because other companies are forced to provide it, and the norms start to change. So perhaps that answers, I think, your question.
I have one question that it says for both, but especially for Professor Fisk. Can you say a little bit more about the role of unions? Have unions been advocating for greater government aid on a broad scale, for shop-by-shop bargains with the employers, both, neither?
Unions have been advocating for greater protections on a broad scale. So, you know, obviously it depends on the union and it depends on the issue, but they have been advocating hard on workplace protection, safety issues, providing personal protective equipment, trying to help workers who are working remotely. They have advocated for a long time for protections for all workers, regardless of whether they're designated as independent contractors or not, precisely because they saw this coming. I mean, anybody who thought about it saw the possibility of economic downturn coming and then wondered what was going to happen to workers when jobs dried up. And so there's been a huge amount of activism and lobbying, both at the legislative level, state, federal, especially to Democrats, obviously, who are typically more receptive and more willing to listen and take the meetings, but also trying to help workers engage in actions to publicize the dangers that workers are facing. And so, for example, the series of strikes that we saw at Whole Foods, Amazon, Instacart were supported by worker groups trying to help workers recognize that the only way they were going to get any kind of change, whether it was quote unquote voluntary from their employer or through legislation or regulation, was by publicizing it. And I would say that one of the things that's really interesting is seeing the amount of news attention that has been focused on labor and workforce issues. It's unprecedented in the last, gosh, probably my whole professional career, that there is at least one story on the front page of the major national newspapers and the local paper every single day about workplace issues. And that's ultimately, I think, what's going to change the regulatory regime.
Professor Polsky, do you have a question?
Hey there, thank you. This is just such an incredibly helpful distillation of so many policy changes in such rapid succession. The question I have relates a little bit to the personal protective equipment issue, and it's about fair wages for what have become hazardous jobs, even though they didn't used to be. And I would imagine in this time that for some employers of essential workers, there are windfall profits. Obviously not if you're, engaged in municipal garbage collection, but if you're Whole Foods or Amazon, I assume there are crazy high profit levels. And I'm wondering about the degree to which there is discussion around hazard pay among unions, and whether there are any employers who are leading the way there and trying to perhaps incidentally shift a norm.
So there have been worker actions around hazard pay. Unions have advocated it, for example, at Whole Foods. The hazard pay, there's no requirement in the law that an employer pay hazard pay. This is entirely something that workers try to negotiate for, usually more effectively if they do it collectively. And sometimes there are union contracts that explicitly acknowledge hazard pay. The hazard pay that I have read about, at least, is in the nature of $2 an hour for a minimum wage job, or a job that's, paid $15 an hour. And so I'd need to be a better statistician than I am to try and figure out whether $17 an hour as opposed to 15, or 14 as opposed to 12, or frankly, $9.25 as opposed to $7.25 is sufficient to compensate workers for the risk.
I will say one thing though, the paid sick leave provision does say that it is full pay or the applicable minimum wage, whichever is greater. So if you are, for example, a worker who is in one of those categories that can make less than the minimum wage, and you're eligible for that sick leave, you do get a little bump from that.
Thank you.
Okay. Ben Eversole has been waiting to ask a question. Ben, you are unmuted now.
Thank you. I was wondering how calculating unemployment works for gig economy workers, because my guess is that, say you're an Uber or Lyft driver, you could still get some rides now, but maybe you're making a third of what you were before. And so, like, how much does that person get? And do they have to be still like logged into the app to show that they're trying to make money, kind of like for normal unemployment where you have to be searching for work?
That's a great question, and I only know the technical details to answer part of it. So for those who are entirely unemployed because of COVID-19 and are a gig or independent contractor, their eligibility is determined based on a federal formula, which essentially gives them the average benefit of workers in that state. because they don't have their own earnings history. It's complicated in California because Uber and Lyft resisted declaring their workers to be employees, but then there was also the possibility that they were employees, but they had no earnings history because they've only been employees since January 1 when AB 5 went into effect. So it's complicated, and we haven't, in California, gig workers are only eligible to apply for benefits starting tomorrow, so we don't actually know a lot about what's going to happen. The question of are you eligible for unemployment if you are still working some, I don't know the details. My sense is the answer is no, because you're still working even if you're working fewer hours. And then, but that may vary from state to state, and they may have created an exception for this crisis. And then finally, do you have to keep looking for work? The ordinary rule is to be eligible for unemployment insurance, you do have to keep looking for work. That rule has been loosened for the duration of the crisis because nobody can safely look for work. I don't know whether all states are the same on that and how long that is going to last. I do know that the eligibility for the $600 a week supplement provided by the CARES Act does not turn on looking for work. And I could figure out the answer to the other question, I would just have to look it up.
So I think we have time for one more maybe. Is there an extension of unemployment for those who are already unemployed, whose benefits ran out or are running out and are still unable to find work?
Go ahead, Katie.
Yeah, I was, if you know the answer, I did look at this, and I believe, what I don't know is if your benefits have run out, whether you can reapply, but I believe that you are entitled to the extension if you are currently unemployed. So maybe Catherine knows the answer to the other one.
I think you're eligible for the $600 weekly benefit even if you've already exhausted your other regular unemployment, for somebody who's already been unemployed for 36 or 26 weeks, for example. But what I don't know is whether the COVID-19 extension for an additional 13 weeks could at least give you 13 weeks, even if you've already exhausted the 26 before we start that. I mean, these are the really complicated details that sometimes vary from state to state. And one of the reasons why I think many states are struggling with administering the UI system is because the answers are not simple.
I think at this point, we're out of time. I want to thank KT and Catherine for their superb presentation. I know it takes a huge amount of time to put together, and I speak for everyone in expressing appreciation. If we could all applause, you hear resounding applause now. We're not going to have presentations the next 2 Mondays because it's exam period, but we'll resume on Monday, May 18th with a presentation by Professor Katerina Linos on international aspects of the coronavirus. Thanks again. And for our students, best wishes for review period and exams.